I think we've hit pretty much a steady number now. So I'd just like to start. So welcome, everybody. I'm pleased to welcome you to this, to LAG's book launch of this new supported housing. And Sue very kindly is displaying it behind her right now. And we're thrilled to have the three co-authors with us tonight. The thing that struck me reading the book was how well you must have got on writing it, because I don't think I've seen a preface like this. And I just wanted to read it because it made me laugh. It says, Helen would like to thank Sue and Dave for being really nice to her. Dave would like to thank Sue and Helen for the opportunity of being in their gang. So, and Sue would like to thank Helen for her incredible knowledge, patience and editing skills, and particularly to Dave, whose contributions made this book richer and basically, I think, helped to get it to fruition. So thank you, the three of you, for writing this for LAG. And yeah, very excited to have you tonight. And I think I've learned quite a lot just reading it and thinking about, you know, my background's a housing law, but as a housing lawyer, I've not really thought about supported housing and really left it to community care lawyers. But to introduce our three authors tonight, there's Sue Baxter, who's a leading housing professional with over 30 years experience in the supported and social housing sector. Her experience ranged from managing specialist provision, including domestic abuse and complex needs, to working for large registered providers. She currently tutors on housing apprenticeship programs alongside providing training and consultancy for housing associations, local authorities and voluntary organisations. Sue is an advocate for customer voice, most recently working alongside experts by experience, producing European-wide training materials. Previous publications include Journeys to Home, Improving the Accommodation Prospects of Young People Leaving Care. So Sue, amazing. And also Sue and I were at Warwick University together, which we didn't know until about a week ago. Helen Carr is a professional, a professor, at Kent Law School and sits as a fee-paid professional.
That's pushing it a bit.
Sorry, you can see, can't you? So Helen Carr, to start again, is a professor at Kent Law School and sits as a fee-paid judge of the First-tier Tribunal Property Chamber. Her research interests are housing, homelessness and social care. Helen recently co-authored Ownership, Narrative, Things, and is a contributor to Pandemic Legalities, Legal Responses to COVID-19. The 16th edition of Law for Social Workers was published in 2021, a book she has been co-authoring for over 20 years. And to join the gang is David Cowan, or Dave, as we can call him as well, who's a professor of law and policy at the University of Bristol Law School since 2003. He has researched and written widely on housing and homelessness issues, as well as land law more broadly. He currently writes the annual Owner-Occupier Update in Legal Action magazine and practices as a barrister at Doughty Street Chambers, where he is an associate member. So welcome, all three of you. We've still got some time for us to explore the book, and I absolutely love the beginning of the chapters about the background of supported housing and really thinking about you know, the move away from Victorian institutionalised care and where we've ended up today. And it does seem, you know, it's incredibly complex and diverse. But Sue, maybe you could just give us an outline of supported housing and what that means.
Okay, thank you. And I think when Helen and I first started writing the first edition, and this was going to be our first chapter, we realised that there wasn't a commonly held definition. So we were actually looking at a blank piece of paper. But I think for us, what we were, you know, kind of what we felt it encapsulated is a wide range of provision, from floating support, so peripatetic support, visiting people in their homes, all the way through to care homes and intensive provision. So, and there's a vast array of, you know, kind of different types of arrangements, in, you know, kind of from women's refuges through to services for people who've got enduring ill mental health, to services for older people, services for young people, particularly those leaving care. So I think when we try to distill it down, I think the things that were common amongst all of these arrangements was that, one, it's a finite resource. So it is actually targeted at those people who, kind of, for want of a better word, are vulnerable or require some type of support, that support is provided. But the purpose is for people to either acquire the skills to live independently, or that they remain independent and, and have inclusivity in our community. And I think we have moved away from that kind of paternalistic provision to more of a kind of entitlement rights-based provision. And that was quite important when we were writing the book, to actually start from that premise.
It's also, I mean, wouldn't you say, Sue, and I don't know whether Helen agrees with this at all as well, but it's kind of a Cinderella service that is very much sort of at the background and in the background, and one for which is always the issue is over resources and the housing benefit, for example, or whatever it is, the housing element of universal credit, etc., etc., etc. It's one of those that we're always fighting for more resources for it, just like we are more generally in housing and legal aid, I guess. But do you agree with that, or are there better times ahead?
I wish, yeah. Dave, honestly.
Yeah.
But I think you're right. And I remember when I first went to work in supported housing, at the time we called it special projects. And I remember going to quite a big housing association and, kind of opening the door, and it said, on the door it said, "Welcome to the wonderful world of special projects." And it was almost a little bit like, nobody quite knows what you're doing there, but we appreciate that, kind of you provide a valuable service. And but I do think you're right. I think sometimes it's difficult for me because this is what I do. So it's difficult to appreciate that people don't really know about it. But I think it is that combination of, kind of providing services to people who are vulnerable, and also the fact that housing is, kind of the last, kind of the most basic provision. So, people, we always are having to manage vulnerable people who live in housing because we're always managing housing. So I do think that you're right. And I think that the other thing that we often get in supported housing is vulnerable people living in very close proximity to each other. Yeah. And that's not something that you get in other forms of housing. But I like the Cinderella analogy. I'm going to keep that.
I think the other thing, not only did they live in close proximity, but the people living in close proximity to each other can have very, very diverse needs, and the potential for conflict or for difficult living problems to arise is quite extensive, isn't it?
Then there's a sort of problem then in the label supported housing, don't you think? Because as a result, because we're looping everything together in this really big kind of container label, that actually we're losing the specificity of extra needs that is kind of required. And the other thing that I think is sort of slightly worrying is I hear of these large scale providers just thinking that actually supported housing just is too costly for them at the moment. Is that something that you both hear about? And so they're sort of trying to divest themselves of it, essentially.
I think that has been a concern that, one is a cost and the other is a risk.
Yeah.
With supported housing. And I think that, kind of as we move towards a more kind of a corporate approach to, kind of different housing provision, there is always that danger. But it doesn't, kind of, it does present a risk, and it is, as you said, the expense involved. I suppose one of the kind of benefits of it being quite complicated, I think, does mean that from time to time the government has decided it's too complicated. For example, if you live in supported housing, you are still entitled to housing benefit, and I think part of that is a kind of government trying to get to grips with supported housing and realising the complexity of it. Sometimes we are, kind of do benefit from that.
Yeah. And when they were trying to reform that and thinking about bringing it into or taking housing benefit and basically removing it, the entitlement, that was when they got into real trouble, and housing providers just saying, actually, do you know what, if you're going to do that, we're out. And all of a sudden, and so that I guess demonstrates the power of the sector in the face of austerity politics.
Yeah. And I do think that one of the things that, kind of we're thinking about times ahead, I do think the sector has been very adaptable. And I think, I think that has served it well through the pandemic, in the, and people have been working very hard to maintain provision during the pandemic. But again, because supported housing has had to manage, an ever-changing environment, it has just been something else that they have kind of, taken in their stride or almost. And that's not to negate all the hard work that has gone in to continuing.
And also from the regulator, I guess, as well. The way in which, the regulatory complex that lies behind supported housing, let's just put it like that.
Yeah.
I think
sorry, Sue.
No. You've obviously started to touch on some of the issues that can arise with supported housing, not necessarily about who gets it. And going through your book, there's different subheadings that kind of you detail. So there are employment issues, there's support issues, there's regulatory, there's public health, there's housing issues, possession, antisocial behaviour, there's bits of homelessness as well, and repair. So taking this forward, you were going to go through, I think, a contract to explore some of these issues as a way of bringing to life some of the aspects of the books, and also to kind of give good practice, I think, before you get to those problems. How can you ensure that things are robust before you get there? So I don't know who wants to take that first.
Shall I start? Because it was very fortuitous. We'd finished this book. We were talking about what we could cover at the launch, and just about then a colleague of mine at the university, who's on the board of a mother and baby project, contacted me and said, we're just about to open up, could you just have a look at our contract and the code of behaviour that we're going to ask our residents to sign, and it's something that we've known right as we do this book, that getting, and we really emphasize it within the book, getting those agreements right at the beginning are something that's really important. And that contract threw up the classic issues that I think we've heard whenever we've done training, and that we keep revisiting every time we have discussions about it. So one of the big things, although there are a lot of other things, is this project wanted to give a license, and that is for housing lawyers, that is always a problem, because it was clear that there were going to be individual rooms given to these to the young mothers. So that was one thing. So we can talk about that. And the other thing, another classic, is that the age range that this project was going to cover was 16 to 19. So we knew instantly there was going to be the issue of 16 or 17-year-olds signing contracts. So we did start discussing it. So I don't know, Sue, do you want to say what you thought?
Well, and I should say that it might be worth saying now that when we did start discussing it, we then started sort of having quite an impassioned discussion. So that's why we thought it was quite good to have it tonight as well. So my perspective is that if the if you're providing supported services to young people because of their vulnerability, and given the nature of the service, that I think that you could argue that it is a license on the basis that the services that young people would require who were new mothers, so at a young age, would necessitate that kind of services and attendance being required at any point of the night or day. And so long as you have got the staffing to deliver those services, then I think it could be argued that it is a license. And I think that's one of the wonderful things about supported housing is it does take you back to first principles and things that us everyday housing lawyers like myself just sort of kind of forget about because we don't necessarily have to deal with them, but are really basic questions. Is it a lease or is it a license? And what happens if the person is taking the agreement is 16 or 17? So the agreement I saw was quite interesting because it seemed in a way to offer exclusivity of the bedroom. But there was a mobility clause, that is to say, the organisation could move the occupier, but it also said we will endeavour not to move the occupier. So it was one of those sort of ones. Well, I suppose empirically, how often are occupiers going to be moved? Are they going to be moved? And then, but it's sort of, and it is absolutely on the borderline, it seemed to me, because you've got Section 11 of the Landlord and Tenant Act essentially written into the agreement, and so you see, this is where we had our row, isn't it? Because because you start from a very different position, I think, than I do, and Helen's nodding. So I don't want to say too much because, but essentially, your position is one from the provider's perspective, and what is the purpose of the scheme. And I think that's absolutely relevant, clearly, but also aren't we in the business of trying to give occupiers the best rights that they can get? Isn't that sort of what the regulator even requires? And that's kind of where I start from. But then there are other provisions in this agreement. So, for example, it is meant to be, well, it says it's kind of short term, doesn't it? But I had a real problem with the term. I have to say that if it is potentially a tenancy, then we're in all sorts of trouble over certainty of term. But and that's the other thing when you sort of start the ball rolling. But anyway, Helen, what do you think?
Well, I mean, I suppose my position, and I think this is the position of a lot of people who come from a background of housing law, that we should be maximising the individual rights given to people. Whilst I acknowledge the problems that Sue raises, and I think also in the context of the pandemic, when we saw the government extend protections for tenancies, but licences were excluded from that, That is another problematic issue, and it's something we see quite a lot when looking at rent repayment orders under the Housing and Planning Act. And so my starting point is it should be a tenancy unless there is really strong reasons why it isn't. But I think this gets us to another point as well, which is the limited legal scrutiny there has been of these sorts of agreements, because the people who have the benefit of supported housing aren't people who go and consult a lawyer either before they sign their agreement or when they're thrown out. And I think that's really important. And perhaps that plays into my feeling that we should maximise rights, because there is no opportunity, or very limited opportunity, for those occupiers to go and assert their rights.
Yeah, and I think that is, I don't know. It'd be really interesting to hear from the audience actually how often they see supported housing cases, because my sense, I'm obviously only very, very part-time at the bar, because I'm a full-time academic, but I've only seen 2 or 3, and generally actually in Bristol. And there, I have seen cases very similar to the one that we're talking about, where, maybe it depends on where the support is being provided, because if it's not being provided in the bedroom, so to speak, if there's a sort of support being provided in the communal area, you do have exclusivity in your bedroom, then we're in a slightly different ballpark. Sorry, Sue.
And I think that is the case, because I think what you know, when you said about moving people around, I almost discounted that part of the contract, because the contract for me, you actually start with and I agree with you, I think we start by saying everything is a tenancy agreement unless there is a really good reason why it's a license. But actually, if we're thinking about the services that people genuinely need in order to you know, kind of to best benefit from this sort of supported housing provision, then actually it's to do with access for me. But I know that you had a different opinion. When we were talking about this earlier, you had a different opinion, because I was saying, well, the only issue is if somebody has got a tenancy agreement, then you are limited as a landlord as to accessing that property. And I thought that was one of the you know, kind of one of the rationales for it being a license, as if you know, the person genuinely needed services and attendance. And I think that's what we're looking at, as opposed to the provider just wanting to use a license because it's easy, because that's not always the case. I would say, you know, looking at this, it'd probably be a protected license, so there would still be the requirement to go to court. So those rights and protections are still there. Anyway, sorry, Sue, you're trying to come in here.
No. I was just coming in there because a question had come in, and please do put the questions in the Q&A. But I thought it related very much to what you were talking about, and it says, it seems that organisations and the legal advice they seek have different opinions about leasehold licences. And I think, as my background in housing law, very much so, and it is problematic. And I think, you know, the question says, which often, what can be accepted as meeting conditions which often contradict each other, which can be very problematic when trying to manage high-risk services and providing the support required within supported provision. So what would you say there? I mean, maybe if you can kind of outline the things that are more likely to point to a license and the things that are more likely to point to a lease, that might give the audience a better idea, perhaps, and also to what's best practice. I mean, you know, my view is probably meets with yours, that, you know, long-term security for somebody, especially someone vulnerable, it should be the starting point. But what's your views on that?
felt like I've said quite a lot, so I'm going to hand over to Helen.
Well, yes. I mean,
as usual.
I suppose the real difficulty is it's with the lease license distinction, it is so difficult. If terms are really there in order to provide services, then yes, it may be a license, but those terms aren't determinative of whether it's a license or not. And I think that's where you go back to it, really. The driver is their exclusive possession, and that's the key characteristic. Having said that, of course, there's the decisions on property guardianship are sort of indicative that a purposive approach is different, but then you can say that property guardianship is essentially a commercial, at the last minute arrangement. And it may be that judges would look differently on a social project where this is not. Nobody's suggesting immediate eviction. I think they said 3 months, which is sort of strange, but reserving the right for immediate eviction. So I think we are in some real difficulty. I think any lawyer who put a bet on how a judge would read it would be a high-risk lawyer. I think it's very, very tricky. I don't know what you think, Dave.
I'm sort of, the property guardianship cases, I think certainly the High Court in Camelot and Kew, I just think is wrong. I mean, I just think it's a bad decision, but I can see that probably some of the people who are here were going to disagree with me. I just think it takes a very narrow view of what's a pretense and what isn't, but and I think you're right, Helen, that purposive approach, so taking into account the purpose of the organisation, is something which I don't think was particularly relevant to the question, but all of a sudden becomes very relevant. The fact that the three of us can sit here. The four of us can sit here and argue about this for 15 minutes, suggests to me that actually the real problem is the inadequacy of the law. And maybe the Welsh in renting homes have got it so much better in just getting rid of that distinction, because why should we be spending so much of our time arguing over this nonsense question, whereas actually the real problem and the real issue is how properly to provide the best support in the best accommodation for what we call, I think, the service user, and that feels to me like the Welsh have got it better. And the sooner we get rid of this nonsense, actually, the better. So I do have Helen and I have a stake in that, but I do think renting homes got it right. Yes, so I've avoided the question, but answered a different one.
I would concur with you, though, because I think that the problem is that we're not going to find out about some of these arrangements until they are actually at court, which is a very inadequate response to an individual and an expensive solution for a provider. And as we've said, actually, David, kind of the supported housing sector being the Cinderella, I'm going to keep that, Cinderella of housing, that it's not hugely resourced. And actually what the problem is a lack of appropriate, affordable housing for people to move on to, the fact that there is a scarcity of high support options, the fact that, kind of there's a constraint of funding for support, you know, kind of the difficulty that we have with statutory services and like social work, police and things like that, and the constraints that they're working to and the workload, you know, that's probably what we should be talking about, but it seems to kind of come back to the least licensed distinction, because what organisations are doing is trying to make something work in an environment that isn't particularly helpful.
Yeah, I can see that we've had a point from somebody who's asked whether they've cracked it anywhere else in the UK or the world. How was it achieved in Wales? I think that it was achieved in Wales just by sidestepping it and just by talking about contracts.
But also there's a separate regime, isn't there, for supported housing?
There's a separate regime for supported housing. Now, whether the Welsh have got it right there is something that I think we could argue about. So in Wales, when the Renting Homes Act comes in to force, which I think is slated for next year, isn't it? There's talk of, providers would have the ability to remove somebody from the service for, I think is it up to 48 hours? It's ages since I looked at it, but I think it's 48 hours, 2 days. You just be excluded. Now, I think that is quite tricky, and but I don't know what you think about that. It's better, I suppose, than excluding somebody from the service full stop, because what we find quite often, those of us who sort of talk to people in the field is that people are just told to go, and they're given sort of 24 hours notice, that sort of thing. I mean, that's just wrong, isn't it? I mean, I'm not getting that wrong. I mean, but that does happen, doesn't it?
Certainly does. I think what's interesting, and obviously the Welsh stuff came from the Law Commission work on this, which is where Sue and I first met, actually, when I persuaded the Law Commission that supported housing needed to be thought about in the context of housing law reform, because nobody really knew anything about it. But the meetings we had there really tried to really drill down to see what it was that providers felt was in the way of giving a tenancy. And at the end of the day, the only problem that was not resolvable was really violence within the property, where and that you have responsibilities to other people who are equally vulnerable. And so really it was that was the power that had to be something to cope with that. And the least licensed distinction was too blunt at all to deal with those problems, but there needed to be something put in place. But I'd like to just come in and say, I think as a sector, we don't, I think it's very rare that people are just asked to leave immediately. And I think that, if you look at, the supported housing providers that I work with, they have quite extensive safeguards in place. And actually, when they're getting to the stage, as regulated by the regulator of social housing, it's to prevent unnecessary evictions. So I think to get to the stage of people being removed is generally because they are putting other people at risk. And having looked at hundreds of supported housing policies and procedures and things like that, that is something that comes through, where people working in the sector are committed to, we only do this if it's in extreme circumstances, and this is about keeping everybody safe. And at some point you have got to balance that up as individual, because the problem is the law's quite individualistic, isn't it? When you get
quite
yes, but then it doesn't take into account always the other people who are put at risk of that remaining there.
So I think the law's much better at doing that when it's dealing with things like nuisance and antisocial behaviour. And you might say it's gone a little bit too far the other way. But I might say that. Yeah, I mean, it is just individualistic, like you say.
Yeah, and I think that it's problematic when you've got lots of vulnerable people living in close proximity.
And I think, Sue, that we do have to. I mean, I hear what you say, and of course, supported housing providers are going to say they only use that power. But what I found when I did some work on this, which admittedly quite a long time ago, there was quite a lot of, shall we say, counselling out of the project, and perhaps a failure to recognize the power dynamics within these situations. If you believe you've got no rights, which is what happens when you purportedly have a license, then it's not surprising at the end of the day that if everybody agrees it's best for you to leave, you leave, because that's possibly your only chance of getting somewhere else to live. So it's none of this is easy.
Well, it also raises a couple of things. One is about choice that people have, which I'll come back to. But I think there are a couple of things in the chat that I think are interesting. One from Harmit Springett. I agree, operating within the legal framework for the private sector is not fit for purpose for supported accommodation. And I think it goes back to what you say at the beginning of your book, that it's so ad hoc. And then we've got Jan Luber saying the discussion reveals the tension between a modern practical relationship for provision of a public service or services and the ancient property law rules of landlord and tenant, and we need a new start. So I think, you know, there are tensions definitely there, and I think there's tensions also, which you've just kind of touched on very lightly there, about the service user, as you know, they're often described, wanting a service, being very vulnerable, and then also they're in a situation where they get offered something they don't know if they can refuse. They don't know what will happen, that pressure may not be put upon them, but that's how they kind of feel, and what are the options if they don't take it. So, you know, how do we address that, with those tensions? Helen? Sue?
Well, I mean, I'm just thinking back to the Mother and Baby project. Those young women probably have no choice whatsoever. And you know that and that's again part of the problem, isn't it, that it's very difficult if you have no choice to then challenge terms of your tenancy or your license in those situations. So I don't know, Sue probably knows better, but I bet nearly everybody they take into that project, and I think it's a fantastic project with all the best motivations, but having said that, it builds in serious inequalities.
But,
I'm just being brought a drink, you know, that's
very impressive.
I'm getting very jealous here.
Cheers, everybody. Well, here's to the book.
Yeah, ordinarily at this stage we would go round with trays of drinks, wouldn't we? But you know what, Dave's doing it all for us. But I think I think it's really difficult, because I think that, you know, we have had this, you know, kind of choice and control agenda in terms of, you know, kind of social, you know, kind of care, and however, it's how realistic that is, as you quite rightly pointed out. We're not offering people generally choices because support funding has constricted, so there is less choice. You know, it's contracted out now. There's probably one provider, whereas, you know, kind of previously, before we went into a contracting regime, there were a number of providers which enabled people to have that, you know, choice, you know, to have a element of choice that was, you know, beyond either you take this or you are, I don't know, Dave, you probably know more about this, intentionally homeless if you don't take this option.
Well, well, where to start really? So my initial feeling, sort of with the academic hat on, is how little academic work there is in the sector as well. There is no empirical work that I know of that deals with how users experience the kind of selection process and the that whole kind of choice, or coerced choice, I suppose we might call it. And I think that's something that really has come. I mean, for me, in being involved in this book, that was one of the things I really did think about. Do you know of anything, Helen?
Well, there was something, wasn't there, by Craig Gurney, who wrote something about the foyer movement?
Yes, so there's been stuff about foyers. I've seen that. But
it was very much a Foucauldian perspective, which takes from the start a very seeing what other people might see as a benign public service as a coercive stroke punitive regime. So that's quite interesting. There's also some work, I was looking at work on the meaning of home, and I think in Australia there's some work around this more temporary accommodation and feelings of home. But these actually, but they're all sociological works, and I think that, you know, there is room for some sensible empirical work on actually to demonstrate the lack of fit of the legal framework with what Jan says quite rightly is, you know, with public service. So very interesting. Perhaps we could persuade the Welsh government to let us look at what happens in Wales, particularly with 48-hour exclusion powers.
Yeah, and I think it's sort of also coming out of some of the chat that I'm just sort of scrolling through, that we're talking about very vulnerable people who, when they try and exercise their rights, are unable to do so because they're met with a kind of stonewalling approach by the provider, or which maybe isn't providing a service. I think there's work to be done with there's academic work to be done with supported housing providers as to the kinds of pressures that they're under as well. So it's not just with users. I think that in order to understand the sector, we need to have a better understanding of both sides of what appears to be a kind of division, but actually isn't a division, because we're all trying to work together for the best interests of the occupier.
I think you're right. And I think one of the things that has been, there has been some work done on choice and control when people are actually within supported housing, which is about, kind of that kind of agenda about listening to experts by experience and customer voice. I did do some European work actually, and you might be a bit shocked to find out that actually we were further forward than significant amount of our European cousins. But that was looking at how people were assessed as requiring, kind of when they required support and also had a housing need, and how that was taken into, how those two things were taken into consideration, how much choice and control people had at that stage. And we did do some work on that. And interesting enough, at the same time that personal housing plans were coming in, and about, kind of how local authorities were assessing individuals. And so that, I think there has been some work done on it, but I think it's, but where you are operating in an environment where it's resource, the choice is, kind of limited by resources, it's actually, kind of quite a difficult, quite a difficult conversation.
We've got probably about 13 minutes. I don't know if you want to take some of the questions or that are coming out of the chat.
Sorry.
The first one might be quite easy because it says, what is Dave drinking?
I think it's called a Pink Russian.
Nice.
I hope there might be some gin in it. But sadly not.
Oh, hopefully soon we will be able to have a book launch at LAG, which is in person, and we can raise a glass to the book. By the way, if people do want to buy, in the chat, Esther has put the code for 20% off until the end of June. But there were a couple of interesting questions that I thought you might be able to pick up on. So about complaints to the Housing Association is one, and then the other one is about little understanding around the tenancy. And if the, it says, I'm continually concerned about the supported living, supported housing services within adult social care, where the tenancy is very much linked to the care and there's very little understanding and or monitoring. It doesn't seem to be improving, and there continues to be situations where the tenant is moved on by providers or a social worker without any consideration of their tenancy rights. Do you think that there's going to be a time when these services are forced to go back to being care homes and where everyone realises that the tenancies aren't real? Has anyone seen this happen? Maybe that's you, Sue.
About
I thought that was a really good, really interesting question, actually.
So about the fact that we've got services that deregistered as care homes, and individuals were given tenancies, but how real is that? You know, kind of how relevant is that to them? As if they've got very little understanding about what that means. And I think this is a dilemma, and I think it's been driven by, you know, kind of, again, it's been driven by funding. I think the problem is I'm always going to keep coming back to this. It's been driven by funding, about, you know, kind of how do you continue to provide an appropriate supported housing provision when, you know, kind of funding is, you know, kind of limited. But I would hope that they wouldn't go back to being care homes. I hope that actually what we do is, you know, I think at one stage we were thinking about how, you know, kind of how do we regulate provision, because it seems that we go from an intensively scrutinised provision in a care home to supported living, where, because it's underneath that supported housing, you know, kind of umbrella as care homes are, but there is less, you know, there's less scrutiny. You have not got the CQC. It'd be interesting to see really about what we get from the social housing white paper about the, you know, kind of increased, you know, to increase the role of the regulator of social housing, whether that is going to, you know, kind of improve that sort of provision, but or whether we, you know, kind of think, well, you know, alongside supported housing having its own chapter in law, whether it needs its own chapter in terms of regulation.
I think one of the problems is that the government is obsessed now, quite rightly, with building safety. But I think improving legal frameworks or making them fit for purpose is probably very low down any agenda at the moment.
There seems to be a few questions as well, if I pull them together, about the agreements themselves, and what can an individual do if services are not provided at all, although stated in the license agreement? So what can people do then?
Go and see a lawyer.
No, I don't know, Helen, come on.
I'm trying to suggest there's work out there for housing lawyers.
Oh, I see. Oh, yeah. Well, undoubtedly. But actually, you know, the simplest thing to do is surely to put in a complaint. And if I saw there was another question that said, well, my complaint hasn't been dealt with for a year. But well, if they don't do that, then the Housing Ombudsman Service is
that's going to be strengthened as a result of the building safety bill.
Yeah, and rightly so, and you know, we're now in a position where all of that nonsense about filters and, you know, are going to be removed. Now, that's really important, I think. So I do think that. Can I just draw attention? So I hope you don't mind, but I just wanted to draw attention to one of the questions about any provider housing young people under 18 years of age, because this is actually where Sue and I came into. Well, this is where I came into this. I think it's fair to say, because Sue said to me, but surely we can just grant equitable tenancies, and I think that's what people generally think is possible, but and I don't know why that kind of shorthand. This is me with my land lawyer hat on. Why how that shorthand is sort of has come into sort of everyday practice, because well, I mean, Sue, were you involved in the Alexander David case? Was that one of yours at Hammersmith?
No, sorry, it's very confusing having two Sues.
Yeah.
Oh, sorry.
But
Sue J.
Dave, what do you think providers have to do then? Not equitable tenancies. What is the correct position?
So I think that the correct position should be that you should try and grant a license if you can.
What was that? Sorry, Dave.
Can't you grant a tenancy to somebody like a social worker in those circumstances?
But my experience has been, when I've done these cases before, is that generally children's services, etc., aren't willing to take on the obligations as trustee of these agreements. So maybe and generally people under 18 want these things because of family breakdown. So the parents won't be willing to take it on. So what do you do? And the other thing is, as long as you know what you're doing as a provider, what is the problem with creating a trust of land in these situations? Okay, there may be issues over getting rid of a person, that is to say, evicting them. But when they become 18, they can apply to take the legal title. They can just take the legal title because it's a classic Rowland, Saunders and Vautier entitlement. But
basically, we've run the whole of this launch to give you the opportunity to say that.
To have this argument, argument with Sue. But I don't know. I don't know. I mean, it's a really difficult question. It's one that comes up all the time in these, isn't it?
I thought it was quite interesting is that aside in Alexander David, which is what, and I can't remember which of the judges actually said that she couldn't understand why, given the age of the, given the age of the young woman and kind of the fact that when you are, a child, you need kind of supervision and support and things like that, why the conditions for a license couldn't be created by supplying that supervision, support, attendance. And I thought that was my takeaway from that, of course.
So, and the other thing that you could do is to grant a tenancy which is not on your normal agreement. So you could potentially grant Oh, it's quite difficult, though. I'm not entirely sure how you do it. But yeah. Anyway, yes, Helen, I sort of agree that actually I did want to really make that point, and I'm so glad that somebody's picked it up in the chat as well, because it's one of my bugbears. Yeah.
What I mean, we've got time maybe just for one more question, and one that kind of springs out here is, and maybe this is common, I don't know, supported housing managers frequently operate as both landlord and care provider. Does the book touch on when and if tenancy should remain separate from care provision? Is that something that's quite common?
It's becoming increasingly, or it did become increasingly more common, that kind of separation of landlord and care. And if that is the case, then I think that makes it, you know, more straightforward. Some of the debates that we've been having earlier makes it more straightforward, because actually it's, you know, kind of, it's like any one of us might need care in our own homes. That shouldn't dictate the, you know, arrangement that we have in terms of our living. But I think it's I think it's less frequent now, because from and you know, my colleagues who are probably on this webinar now will probably concur. There's a lot of the floating support contracts were the first contracts to be decommissioned when the ring fence came off supporting people.
But the agreement that we've got, they've got a tenancy, a license agreement, and then they've got a service agreement. And from my point of view, that is the right way to do it, because you shouldn't have terms in a license or a tenancy which don't relate to the occupation but relate to other matters. So that's how I would understand this.
But then again, in the license agreement, it says you've got to accept the support that's provided.
Yes. Yes. Well, how do you enforce that?
They are interlinked, shall we say?
They are. But there are some terms in there, for instance, that you must apply for cold weather payments that we did talk about, and that definitely should not be in an agreement. So you can't force anyone to apply for benefits.
No, that's absolutely right, and that was a real problem in that agreement.
Yeah, fair contract terms, and I think that's
but it is the kind of thing that you do see in supported housing agreements, precisely because, as Sue J said earlier on, you know, we're talking about kind of coerced choice, and that is you know, you just accept what's there.
And even if it's benign, the intention is benign. And here, clearly, the intention is to maximize income. That doesn't stop it from being inappropriate.
I mean, one thing that I was thinking, you know, when you've got a dispute between an employer and an employee, the employer has to pay, you know, if you resolve it, the employer pays for that advice for you to resolve the agreement. And it seems to me that, you know, part of it might be that, you know, people should have a right to access to a lawyer before they sign these agreements, or, you know, some kind of safeguard. I mean, these are incredibly vulnerable people on the whole, and are accepting terms and conditions that they may not understand. I mean, we haven't touched on capacity, and I'm very conscious that it's now 6 o'clock. I mean, I don't know if there's something you want to say about that, or whether we just kind of wrap it up now, unless you've got anything further to say about capacity. But I think that's a big issue, isn't it, in terms of
very big.
So and the book does deal with capacity in various places, and clearly it is the issue. I just think that I actually wanted to come back to the point that you made, Sue, about legal advice. And the real importance of delivery of good quality legal advice to both users and providers, because I think, you know, nobody's trying to screw the other over here. I mean, I'm strongly of the view that actually people are just trying to do the right thing. But good quality legal advice is, as we know, after LASPO and all the rest of that, really quite problematic with advice deserts.
Yeah, but also with LASPO, you can't get agreement, you can't get advice on the agreements now, and that's really short-sighted, because if you could get advice on the agreement, you can iron out the problems before you actually get to the crisis point. And we know that in terms of early advice, it doesn't work taking that away. But it's been brilliant to hear from the three of you. It's been like really interesting discussion, and clearly you get on so well. And I think there will be other people applying to be in your gang for your next. That is what I'm surmising. Interesting that you should also mention about Cinderella, this being the Cinderella of services, because Ken Loach said that homelessness was the Cinderella of all Cinderellas. So I think there's a layer of Cinderellas, and maybe that's just about public services that we have now in this country, really. But I would like to thank you, the three of you, for writing the book and for being brilliant tonight. I'd like to thank Doughty Street for hosting for us, and Esther for being your publisher and getting the book to us so that we could do this launch. And thank the rest of you for coming tonight. And if you do want to buy the book, again, 20% off until the end of June, and the code is in the chat. But thank you all for coming.
Thank you.
Thank you.
Cheers. Thank you very much. And thanks, Sue, for hosting.
Yeah.
Brilliant. Thank you.
Yeah.
Cheers.